Good evening, students. The last chapter of your syllabus, it is the Supreme Court. So today we are going to do about the Supreme Court. So what do you mean by Supreme Court? Under our constitution, the judiciary is a single integrated system of courts for the union and the states, with the Supreme Court at the apex. Apex means at the head. Supreme Court is the head of the entire system and not only supervises but also exercises control over the functionings of other courts. There are no separate sets of laws, and a single civil and criminal system operates throughout the country. All cases coming from the lower court can be taken to the High Court and then finally to the Supreme Court by the way of appeal. So Supreme Court is the head of the entire system and not only supervises but also exercises control over the functionings of the other courts. Now, composition. The Supreme Court of India consists of a chief minister and not more than 30 other judges. If the judges are to be increased, then a law or they can say that the parliament can give the consent with the majority. Qualification. First of all, the judge person to whom the judge is to be made should be the citizen of India. Secondly, has been for at least 5 years. Again, 5 years a judge of High Court or 2 or more such courts. Then he should be at least 10 years an advocate of a High Court or 2 or more such courts. Or, in an opinion of the President, if President feel that it is a distinguished jurist, then also he or she can be elected as a judge of the Supreme Court. Now, every judge of the Supreme Court is appointed by the President of India with the consultation with the judges of the Supreme Court and of High Court. Okay, and then term, as you know, that a judge of the Supreme Court shall hold office till he attain the age of 65 years. Please remember, a judge may resign his office by submitting his resignation letter to the President, or if he is found guilty or you can say that not going proved on the ground of misbehavior or incapacity, he can be removed by the process of impeachment. Clear? Now, in this video, we are just doing those topics only which are in your syllabus. All topics we are not covering. Now, what are the functions of the Supreme Court? So, functions of the Supreme Court: settlement of disputes. First of all, original. All you can say, sorry, before that it is a jurisdiction and powers of the Supreme Court also. First of all, it's a center state or interstate disputes. All the cases, those who are related to center state or interstate, they will be coming to the Supreme Court. And these are such kind like between Government of India and one or more state, between Government of India and any state. Okay, so these are the cases, those who are center state or interstate. But certain exceptional cases are there, that these kind of cases, though they are related to the center state or interstate, but will not come directly to the Supreme Court. Why? Because a dispute arising out of treaty agreement, already Supreme Court has given the decision, or it is related to the interstate water disputes or finance commission, etc. Adjustment of certain expenses, pensions, etc. Then protection of fundamental rights. Now, all the cases related to the fundamental rights, protection of the fundamental rights, they will be taken to the Supreme Court only. Then transfer of cases from lower courts. The cases from the lower courts where it's a question of importance, great importance, and the lower courts feel that it should be solved by the higher court, Supreme Court, then it should be given to Supreme Court. Then interpretation of the Constitution. All the amendments to be done in the constitution will be done by the Supreme Court only. So these are the original jurisdictions. Next, it is the appellant jurisdiction. Appellant jurisdiction, by it means that when an appeal will be done in order to solve that case, like that case has come to the court, high court, and within an appeal that case has been transferred to the Supreme Court. These are related to constitutional cases, okay, civil cases, and the criminal cases. Next, it is the functions. Now, original jurisdiction. It's a very necessary that the judges of the Supreme Court, they should solve the dispute between the central government and one or more states and the union territories. On appeal, the Supreme Court deal with appeal which are made to the respect of the original jurisdiction. Okay, then appeal by special leave. Under the leave, the Supreme Court can allow the leave to the against the judgment of an court of India. It's in the case of civil cases also, in the case of criminal cases also. And when the Supreme Court could squash the decision of a tribunal when the tribunal exceeded from his jurisdiction. Then enforcement of the fundamental rights. In order to give the fundamental rights to the people of India, many writs has been given, many orders. It's a writ in the form of orders. They are to be given by the Supreme Court and the High Court. The first one, it is a habeas corpus, which means to have the body. By issuing such kind of writs, the High Court or the Supreme Court can get the body of any person released if it has been unlawfully detained. Means any person who has been kept into the jail will be released as soon as possible because he or she has not done anything. Then mandamus, we order. It means we order. It is a command from the superior court to the lower court to perform the duties properly. Writ of prohibition is an order issued by a Supreme Court to the lower court to stop the proceedings. Writ of certiorari, it is again issued by the Supreme Court to be informed of what is going on. That what is going on, that is to be informed. Clear? This writ of certiorari and writ of prohibition, they are the same, only little difference it is there. Q warranto. Q warranto, it means but why what order.